Hello students, welcome back to One Stop Law. Now this is a very short video to give you a quick update on the recent development in the hijab ban case which is going on in India recently and the judgment delivered in the Supreme Court yesterday. So in a significant development, the Supreme Court of India on 13th October 2022 has delivered a split verdict on a batch of appeals challenging the March 2022 Karnataka High Court order that had effectively empowered the government colleges in Karnataka to ban the wearing of hijab by Muslim girl students in the college campus. Now, if you remember, students, that earlier this year in February 2022, the Karnataka government had banned hijab inside the educational institutions in the state. This government order was challenged in Karnataka High Court, which in March 2022 had upheld the impugned government order of banning hijab in educational institutions in the state of Karnataka. I have made already three extensive videos on this issue, like what was this dispute all about, how the state handled it, what was the legal status on freedom of religion and ban of hijab before the Karnataka High Court gave its judgment, and a detailed analysis of the Karnataka High Court judgment. So I will attach all those links along with this video in its description box. You can check that out. So what happened? Soon after the decision of the Karnataka High Court, more than 2 dozen appeals were filed against the Karnataka High Court judgment in the Supreme Court of India. The matter was taken up for hearing by a two-judge bench in September 2022. After hearing the arguments put forward by both the parties for 10 days, the bench had reserved its judgment on 22nd September 2022. Yesterday, on 13th October 2022, the two-judge bench of the Apex Court pronounced a split verdict on this hijab ban issue. The two justices were Justice Hemant Gupta and Justice Sudhanshu Dhulia. As a result of the split verdict, the case will now be heard by a larger bench of the Supreme Court. Justice Hemant Gupta dismissed all the 26 appeals filed against the Karnataka High Court judgment, which held that the hijab was not an essential religious practice of Islam and had allowed the ban on wearing hijab in educational institutions in the state of Karnataka. But while expressing a divergence in his opinion, Justice Sudhanshu Dhulia have set aside the Karnataka High Court judgment and has ordered removal of all restrictions on wearing of hijab in the state of Karnataka. Justice Hemant Gupta significantly delivered this judgment just a day prior to his retirement from Supreme Court and as the judge of this country. He had said in his judgment that hijab is not an essential religious practice of Islam and the state order of Karnataka serve the purpose of access to education. In his order, Justice Gupta has framed 11 questions relating to whether an appeal should be referred to a constitutional bench of the Supreme Court, the rights of the college management, the rights enshrined under Article 19, under Article 25, and many more such questions, and has answered all these questions against the appeals. On the other hand, Justice Sudhanshu Dhulia has said that venturing into the essentiality of wearing hijab and the entire concept of essential religious practice was neither an essential part of this dispute nor required to be decided in this particular case. He has held that the Karnataka High Court has adopted a wrong path. During the pronouncement of the judgment, Justice Sudhanshu Dhulia said, and I quote him, "The thing that was most important in my mind while deciding this case was the education of a girl child. It's common knowledge that already a girl child, primarily in rural areas and in semi-urban areas, has to face a lot of difficulties. She has to help her mother in daily chores, in cleaning and washing before she goes to school. There are many other difficulties as well. So, what I asked is, are we making her life any better?" He further said, and I quote him, "There was a question in my mind. I have quashed the government order of February 5 and have ordered the removal of all restrictions. I have held the case. The judgment in Bijo Emmanuel squarely covers the issue." Justice Dhulia further said, and I quote him, "The Karnataka High Court took a wrong path. it is ultimately a matter of choice, and Article 19(1)(a), that is freedom of speech and expression, and Article 25 Clause 1, that is freedom of religion. It is a matter of choice, nothing more and nothing less. So we see that where in the same case Justice Gupta has dismissed all the appeals, Justice Dhulia not only allowed all those appeals but have repeatedly pointed out that it is a case dealing only with right to choice, freedom of speech and expression, and freedom of religion. So, in the light of this split verdict of the apex court, the bench has now directed the case to be placed before the Chief Justice of India, Justice E.V. Lalit, for further appropriate directions. So that was all for this video. I just gave you a quick update on this case. Till I see you in some other video. Thank you all.